trades and manual labor. Most recently, as a sole member, as stated, of Extreme Excavation. As the name in their title says, they do excavation work in driveways. Mr. David Hayes was the plaintiff in the case. Mr. Hayes resided in Oregon and California and was in the floor covering business for over 25 years. He relocated to East Tennessee in 2021, and he bought a piece of property on Charlie Hicks Road in Washington County near Jonesboro, the county seat. And he decided he wanted to build a home here in East Tennessee, and so he hired a builder and he hired a driveway construction man because the house was going to be set some 350 feet off the road, and it was going to require a 350-foot driveway. The person he hired to do the driveway got sick, walked off the job, didn't show up. Mr. Hayes asked his builder who he should get, and he recommended Extreme Excavation, Mr. Lane, my client. So in October of 2021, Mr. Lane met Mr. Hayes out at Mr. Hayes' property to discuss what Mr. Hayes wanted. And at the time, Mr. Hayes said he wanted a 350-foot driveway, that the fellow who'd been there before had just basically done the outline of the driveway, but had left truckloads of dirt in what was to become his front yard. And he said, I need a 350-foot driveway. I need a pad for my truck with a camper on it so I can park it there. And then I need a water line and an electrical line. And Mr. Lane said, I can do that. And they agreed on $15,000. And that's in Exhibit 1 in the trial testimony. Now, at this point, it's important to note that Mr. Lane, my client, recommended that Mr. Hayes go ahead and build his home before he built his driveway. Why? If you build a driveway while a home's being built, you're going to drive construction materials over that driveway, you're going to damage the driveway, and there's going to be a negative synergy between the two projects. Well, Mr. Hayes said he wanted to go ahead and have the driveway and get it done right now. So at that point, Mr. Lane said, fine, we'll go ahead and do your driveway, but we'll have to work side by side with the builder, and they proceeded to do that. And that comes to the second part of Exhibit 1, which is the contract. Besides the driveway, besides the water line, beside the electrical line, Mr. Lane was asked to dig out and fix some of the foundation work that the builder had done on the house because it had become flooded. So for an additional $1,500, Mr. Lane agreed to do that as well. So the total price was $16,500. Mr. Lane began work in late October of 2021. There was no time limit specified in the very brief contract, but he proceeded to finish the project some 6 or 7 weeks later. Now, during the middle of the project, it's important to note that because this house was being built next to it, Mr. Hayes noticed that the pad that he wanted for his truck with his camper was going to be too high for the house so he could park his truck in the garage. So he asked Mr. Lane, can you go down further on the pad so I can park my truck with my camper level with the garage? Mr. Lane said, we can do that, but when we do that, you're going to have a wall, a wall that's going to be about 4 feet high. And once you get up to 4 feet, you got to start talking about retaining walls, or at least putting sod, seed it, get some grass so it doesn't erode. And Mr. Hayes said, well, I needed the camper pad down lower, but I can't afford to fix the wall. Sorry. Well, at this point, he already had a camper pad down lower, and he had the wall, but he didn't want to do anything about it. And that's where the problem came in. Mr. Hayes didn't have any problem with the driveway, didn't have any problem with fixing the foundation. What he had a problem with was the wall that resulted from him asking Mr. Lane to dig down deeper for the truck pad, okay? So, Mr. Lane finished his project. He left the project. The builder proceeded to do his thing, finish his thing, and At this point in early 2022, Mr. Hayes filed suit in our local General Sessions Court. Mr. Lane counterclaimed. The matter went up to Circuit Court. We did discovery. Case was set for trial in January of last year. A couple of months before trial, we received an offer of settlement for $15,000. 4 days later, I think we counterclaimed for $25,000. I said everything else was fine in the settlement proposal. A couple of days later, they came back and said, looks good to us, that's fine, we got a deal. So at that point, you do what lawyers do, you set it aside, you move on to the next case.
Did he say we have a deal, or did he say something like we can finalize the settlement when I get back?
In my opinion, the exchange of letters between the two lawyers said, the offer from Mr. Hayes said $15,000 plus a settlement agreement and an order of dismissal. My response to that said, everything's fine except $25,000, to which the response was accepted, okay? So the amount was agreed to. The fact that there would have to be documents to finalize the case was, of course, a natural part of any lawsuit. And then 4 days after the counteroffer had been accepted, we were advised that that was being withdrawn. We moved to enforce the settlement agreement. The court, without hearing proof, said that the actual settlement agreement and not the agreement to have a settlement agreement and the amount of the settlement, the actual settlement agreement was central to there being an enforceable settlement agreement, and the court declined to enforce it. We proceeded to trial. At trial, there was testimony from Mr. Hayes that everything that Mr. Lane did on the Exhibit 1 was done and done properly. Mr. Lane testified he did everything. His assistant, Mr. Meade, said everything he did was right. The expert, Mr. Thompson, said everything was right. This was the Exhibit 5 in the court file. This is basically what it looked like when Mr. Lane finished up.
Excuse me for interrupting, counsel. Did the trial court make specific credibility determinations with regard to the work done?
I'm sorry, I didn't mean to interrupt you. I did not hear I did not see anything in the court's opinion about credibility determinations. The court proceeded to hear the testimony and delivered its opinion, and at the conclusion of the trial, the court determined that Mr. Hayes should recover $17,500 for alleged remedial work that he had done after Mr. Lane finished. Now, significantly, Mr. Hayes produced no receipts, no contracts, no canceled checks, nothing that would indicate that anything he alleged to have done was done. I cross-examined him and I asked him, well, were any of the materials reused? Was it the same project? Was the length of the driveway the same? And to none of those did he have any answers. Despite that, the court determined that the remedial work that he alleged to have done was compensable. And again, this was the way we left it. That's Exhibit 5. And that's what our expert said he saw too, and that it was fine. On our counterclaim, we testified that Mr. Hayes asked us to do additional work over and above what was in Exhibit 1. There was unrebutted testimony from Mr. Lane and his assistant, Mr. Meade, that work to the tune of $67,500 was done over and above what was in the original contract. And this was work like hauling 40 dump truck loads of dirt out of there, so it wouldn't be, you had to go somewhere, and Mr. Lane agreed to do it after Mr. Hayes asked him to do it. There was also further work he did digging utility lines, and unrebutted testimony that was worth $67,500. The court, in ruling on that, said, you don't have any documents, I don't think your claim has any merit, and dismissed it. And that's it. That's all the court said. And it's our opinion, respectfully, that without any findings of fact, and really not any in allowing the original claim, this court should review the record de novo on the facts. And then, of course, we ask for enforcement of the settlement agreement. And that would pretermit the trial issues.
The hauling of the dirt, wasn't that anticipated when the contract was formed?
I don't think so. Remember, he was...
I thought you
excuse
said at the beginning that there was dirt to haul too.
The original road builder did leave a bunch of dirt in what became the front yard. That's correct. But remember, Mr. Lane was asked to do additional digging work to take the pad lower, and he did that for a significant length of the road that created additional removal of dirt issues. So, yes, Your Honor, there was some original dirt there from the first road builder, but we're saying that the work that we did over and above that should count too.
Okay, thank you.
Thank you.
May it please the court, I'm Mark McFall from the Washington County Bar, and I have to beg the court's indulgence. I'm getting over a bad head cold, and I'm hoping my voice will hold out today. As the trial court noticed in its final judgment, Your Honors, this case is very much a he said case. The Exhibit 1 that was referred to by Mr. Taylor was the only piece of documentary evidence of what the parties agreed to be done, and there was no documentary evidence of this additional work that Mr. Taylor refers to. But in any event, I want to begin with the settlement agreement. That's the first issue we both listed for review by this court. The defendant's coming to this court for the third time to enforce this purported settlement agreement. And in our brief, we set out exactly what the correspondence were that are relied on in this case. October 14th, I sent a letter to Mr. Taylor, and it had 3 points to it. David Hayes would pay Extreme Excavation $15,000 in full and final settlement. The parties would execute a settlement agreement containing mutual general releases, and there would be no admission of liability. And finally, an agreed order of dismissal with prejudice would be filed. Then by Mr. Taylor's letter of October 19th, he made a counteroffer for $25,000, as he stated. And then I sent him an email on October 22nd. And actually, I was on vacation in Panama City Beach at the time, and I sent him an email and said, well, my client had accepted that, but I'll be back in my office on October 31st, and we can finalize the settlement when I return. And Judge Bennett, you noticed that, I believe.
What terms were left to finalize?
Well, I think one of the terms, the amount of money was not, the amount of money was initially agreed to, but the terms of the payment of that money, I don't think had been agreed upon. I think my client was contemplating perhaps a structured settlement of some kind. So we didn't get into those details until we were going to start drafting some kind of a settlement agreement. But before that, my client instructed me withdraw the settlement offer, which I did. So we did, the defendant did file a motion to enforce that settlement agreement. We had a hearing, and as correctly noted, the trial judge denied that motion. Now, the cases cited by the defendant, I think, are all distinguishable from the facts in this case. And actually, my research has not yielded any case authority with that's on all fours with this fact pattern. They cite the Moffitt v. Carmen case, where after a lawsuit was filed, the parties entered into a detailed written settlement agreement that could be made into an order of the court if the parties defaulted on the settlement agreement. And apparently that happened. The order was sent, but before it reached the court, the other side, the parties that agreed to the settlement, filed a motion not to enter the order. They also cite the Harvey v. Turner case, and in that case, the parties' attorneys, by agreement, appeared before the court without the parties, stated on the record what the specific terms of the settlement agreement were, and it consisted of a confidential agreement about a payment of a sum of money and acceptance of a survey for a boundary line. And finally, in the Beeman Pontiac Company versus Gill, a automobile dealer's attorney drafted a settlement agreement to resolve the lawsuit, mailed it to the defendant's attorney. The defendant's attorney approved it, had his client sign it, and he mailed it back to the other attorney with a check for the settlement amount. But before everything got finalized, the defendant's attorney withdrew the settlement. In that case, this court did enforce a settlement agreement, but as pointed out, there was a drafted, detailed settlement agreement in that case too. So all these cases had more concrete terms that were agreed to by the parties, either by a written signed settlement agreement or as stated in open court. Here we had clearly not consummated a signed written settlement agreement, and all my correspondence contemplated that a settlement agreement would be necessary to resolve the case. So we believe the trial court correctly denied the defendant's motion for enforcement of the settlement agreement. Now, let's kind of turn to the he said part of the case. Mr. Taylor, in his brief, takes issue with the court's findings of fact in the final judgment. And the court did recognize that, as I've stated earlier, there's a dearth of documentary evidence in this case. There's a single document that's Exhibit 1 to the trial record that contained what would be done to build the driveway and how much tonnage of shell, how much tonnage of what's called crusher run in the breeze, which is a form of gravel. So, and Mr. Lane, interestingly, didn't present that to my client until after all the work, he said all the work was done. There was nothing signed before anything happened, which became a problem. And so we didn't have a signed contract. We didn't have any signed change orders, which in a perfect world would have probably saved the day here. The defendant took issue with the trial court's findings about their expert, Greg Thompson of JTB Construction. We assert that the trial court correctly addressed Mr. Thompson's testimony, and the court acknowledged Mr. Thompson did opine that the driveway was okay or, quote, up to standard. But he also testified that he observed when he came out to inspect the driveway, it was an exceptionally rainy day, and he observed rainwater runoff going into the foundation of the plaintiff's house. We concede that he rendered an opinion that the driveway was up to standard, and I assert that the trial court took that into consideration and weighed that testimony appropriately in the final judgment.
Is the expert's testimony at issue here? as an expert, or are we just
I
discussing
don't
the
think
facts here?
Well, no, the expert's testimony is not an issue other than they took exception to what the trial court found in the final judgment as to that testimony.
Okay, thank you.
And importantly, the trial court found that neither Mr. Thompson, the expert, nor any other witness testified that this rainwater runoff, which became really a big issue in the case, in the briefs, I'm sure the court saw that the issue was as the trial court described it, a vertical clay wall. And it was red clay, and your honors have seen red clay in Tennessee, and it will run off on a sheer wall like it was there. And so that became an issue, the rainwater runoff. But the trial court found that that there was no testimony that was not a condition created by the defendant, the rainwater runoff issue. They also assert the trial court failed to make findings about the origin of the vertical clay wall, but the trial court made specific findings in the final judgment. In paragraph 13 of the final judgment, the court refers to the vertical clay wall and also said that the testimony was the wall was a problem and needed to come down. And the court specifically found that the defendant created the vertical clay wall. Now, this vertical clay wall issue was hotly contested at trial. There was contradictory testimony going both ways. And I know the court has inquired about credibility. Yes, the court did address credibility, and in fact, the court found credibility issues on both sides of this case. But respectfully, I believe that the trial judge correctly weighed and considered all the evidence, judged the credibility of the witnesses, and made the correct decision. Now, as far as the defendant's counterclaim, the trial court found and stated in the final judgment that the $67,500 number was extreme based on the numbers presented. Mr. Taylor said that the evidence on the $67,500 was unrebutted. However, there's a lengthy colloquy between the court, Mr. Taylor, and his client about the receipts that were submitted for the tonnage of shell and crusher run that were used on this driveway. And the court ultimately found that it didn't match up. The receipts didn't match up with what was in the Exhibit 1 as far as the tonnage for shell and crusher run. 240 tons of shell, 110 tons of crusher run. And the court couldn't find from the documents submitted that that was correct. And her finding is based on all the evidence, all the testimony, and as the case authority directs this court, those findings should be presumed to be correct, unless there is evidence of a strong nature to the contrary, and I don't think we have that in this case. I think it's very much, I think the judge did a good job in weighing this testimony and evidence and coming up with a ruling. Interestingly, too, Mr. Lane testified at trial. He didn't even present the plaintiff with any kind of an invoice, statement, nothing that details this $67,500. He just came up with it at trial for his counterclaim and said, I did all this additional work and I want to get paid for it. So respectfully, we would ask this court to affirm the final judgment entered by the trial court. Thank you.
let me work backwards from what he counsel referred to the colloquy between counsel and the trial judge concerning the tonnage of the material that went into the driveway. That happened. That did happen. It's somewhat mysterious to me why it happened, but it happened. And there was an explanation of what sometimes things were referred to as shell, sometimes as crush and run, sometimes as aggregate base, but the numbers worked, although respectfully that wasn't relevant to the outcome. What I want to address here is that interlude between the trial judge and myself about the tonnage in the driveway had absolutely nothing to do with the counterclaim. That had to do with the work that was over and above what was on Exhibit 1. And there was a reference from this podium, there were references in the brief to this colloquy about the tonnage of the material, and respectfully, that had zero to do with the counterclaim. So that's the first thing. Working back again, reference was made to the trial judge's findings about the water in the foundation and where it could have come from. And the court made a finding that there was nowhere else this could have come from. There was no testimony that it could come from anywhere else but from what Mr. Lane, the driveway builder, did. That's simply not true. The builder of the house, Mr. Hayes, the plaintiff, testified the builder caused the runoff in the foundation. That's in the record. I think it's page 75. And it's just respectfully a misstatement to say there was no finding that it came from anywhere else but Mr. Lane. Now, Exhibit 1 was very humble, and it reflects people doing striking a deal in the front yard. It happens all the time in Tennessee, particularly East Tennessee. But it was straightforward. It had 5 or 6 things that were to happen. And I know on at least 4 occasions in this record, Mr. Hayes, the plaintiff, said that every single thing on that Exhibit 1 was done. It was all done. And for there to be any kind of suggestion otherwise is just not accurate. Even he admitted it, and both Mr. Lane and his assistant said everything was done. So I want to spend my last couple of minutes on the settlement agreement. If we look, the Moffitt case, the salient holding in Moffitt is an agreement to settle a lawsuit voluntarily entered into is binding upon the parties, whether or not made in the presence of the court and even in the absence of a writing. That's Hornbook law. That's Moffitt. Harvey's salient holding is, if the agreement contains the essential terms of the transaction, it indicates the parties intended to be bound to consummate the transaction. In this case, the essential terms were a sum of money. At the end of a sum of money, in a sum of money case, there's always going to be a settlement agreement. There was absolutely nothing mentioned about a structured settlement or anything like that. It was a sum of money, period. The settlement agreement flowed naturally from the settlement amount, and that's what means consummation of the transaction. And the Beeman-Pontiac case, the important holding there is the parties to a bilateral contract bind themselves by their mutual promises to perform. Thus, the exchanged promises serve as consideration for the contract. And there was some reference to mailbox rule and more formal agreement in some of these cases. If you cut through the chaff to get to the wheat, none of that matters. If the parties agree to the essential terms, everything flows from that. And respectfully, in this case, I don't know what else could have been said in the correspondence. It was done, it was settled, we agreed to it, and then it wasn't agreed to. So we're asking this court to enforce the settlement agreement. That should end the case. If not, Our position is as stated on the trial earlier, and I'm done with time. Thank you. Appreciate your consideration.
Thank you both. And I believe we're going to take a brief recess here to make a change, and we'll be right back. Don't go anywhere.